So the state of California is now asking the Ninth Circuit to uphold their magazine ban based on a recent mag ban decision in another appellate court. So let's talk about what is happening. Also want to mention that the Gundy's voting is currently open. You can vote for me using the links down below. I'm in the category of Influencer of the Year, so I'd love your vote. And then also our podcast, Liberty Lounge, is in the category of Podcast of the Year. You can vote every single day. And then also when you vote, you're entered to win some prizes, and links to all of that will be down below. As I mentioned in the intro, in this video, I have an important update for you in the California magazine ban case called Duncan versus Bonta. You may recall that recently a Ninth Circuit en banc panel decided to break all of their rules and take review of the California magazine ban case immediately, and they did that to essentially prevent any positive to a ruling. One of the good things about this is the fact that the Duncan case is now one of the furthest cases along in the process, which deals directly with a state's ban on magazines. Now, currently, oral arguments have taken place in this case, and now we are waiting anxiously for the en banc panel in the Ninth Circuit to issue their decision. But since those arguments took place in front of the Ninth Circuit, a lot has developed. Recently, we talked about how the state of California submitted an 8-1 decision in the Rahimi case out of the Supreme Court, and they're trying to use that as support for their magazine restrictions. And now the state of California has also submitted a ruling out of the DC Court of Appeals, which upheld a similar magazine ban, and they're trying to use that as support for why California and their restrictions on magazines should also be upheld. This law was challenged in a district court, and the judge there, Roger T. Benitez, issued a ruling which found that this law in California was in fact a violation of the Second Amendment. This led to what is known as Freedom Week in California, where for a week period of time, people were able to finally once again purchase magazines that hold more than 10 rounds. However, of course, California did not like that, so they appealed that decision up to a 3-judge panel in the Ninth Circuit. A 3-judge panel in the Ninth Circuit reviewed that decision of the lower court and ultimately did agree with Judge Benitez. Then the case went to the Ninth Circuit en banc panel for a first time on appeal. And on review, the Ninth Circuit ruled in favor of the state of California, upholding their magazine ban. That decision by the en banc panel was then appealed up to the United States Supreme Court. A writ of cert was sought, and then this case, Duncan sat in front of the Supreme Court. It was on hold until the Supreme Court issued their Bruen decision. After the Supreme Court issued their 6-3 decision in Bruen, correcting the type of analysis that should be applied in all 2A cases, which is text as informed by relevant history and tradition, the Supreme Court decided to GVR, which means they granted, vacated, and remanded the Duncan case back down to the Ninth Circuit. At that time, the Ninth Circuit did not want to get involved with any 2A cases, so they sent the Duncan case all the way back down to Judge Benitez. Judge Benitez reanalyzed the case and then issued a new decision, but simply reaffirmed his prior ruling and used the even stronger language that was given to him by the Supreme Court in Bruen. So once again, California lost in the magazine ban case, but of course they decided to appeal up to the Ninth Circuit. This case was set to be re-reviewed by a 3-judge panel in the Ninth Circuit, but then something unprecedented happened. The Ninth Circuit then issued an order, and the Ninth Circuit en banc panel that had prior reviewed and upheld the magazine ban in California decided to take this case as a comeback case. So they took it out of the hands of a 3-judge panel in the Ninth Circuit that was set to review the issue. They took it on their own, and really they did that so that they could avoid any positive to a ruling happening in this case. Then the Ninth Circuit en banc panel issued a stay on the Judge Benitez decision until they rule in this case. Now, in that decision, the Ninth Circuit en banc panel argued that they believe the plaintiffs were not likely to succeed on the merits of their Second Amendment arguments, and many of the judges on the panel actually had issues with their colleagues in the Ninth Circuit taking this case as a comeback. They actively called out their colleagues in dissenting opinions, saying that their colleagues in the Ninth Circuit were going to violate the Second Amendment, that they were breaking the rules to take this case as a comeback, and they were doing this for the express purpose of violating the Second Amendment. But ultimately, the Duncan case was argued back in March in front of the same Ninth Circuit en banc panel, who already once have actually found that the magazine ban was valid and that it does not violate the Second Amendment. Now, during those arguments, there was a lot of debates about the Ninth Circuit breaking the rules. There was also debates about how Bruen and the historical analysis would apply to these magazines. And finally, there was also some discussions from some of the judges about maybe holding the Duncan case until the Supreme Court issued the Rahimi decision. Now, coming out of those arguments, I don't think anyone was thinking that the Pro 2A side was going to walk away with a win because, again, this is the same en banc panel. And if you just listen to some of the questions during the oral arguments, it's very clear that they want to rule the same way. But now California is trying to weaponize multiple decisions that have happened since those oral arguments as support essentially for why the Ninth Circuit en banc panel should once again uphold the magazine ban. Recently, the state of California submitted supplemental letters of authority arguing that the Rahimi decision, that the Bianchi case out of the Fourth Circuit, and then now a DC Court of Appeals decision all support upholding the magazine ban. California argues that under Rahimi, California should win this case because they presented sufficient historical evidence to support their ban. The letter that California submitted to the Ninth Circuit states that Rahimi reiterated that the right secured by the Second Amendment is not unlimited, does not sweep indiscriminately, and is not a right to keep and carry any weapon whatsoever. The court recognized that some courts have misunderstood the methodology of Bruen and Heller, which were not meant to suggest a law trapped in amber. They went on to state that Rahimi criticized the Fifth Circuit for committing the error of reading Bruen to require a historical twin rather than a historical analog. They argue that that is the same error committed by the District Court Judge Benitez. So California argues that Rahimi supports their magazine ban, and they also went on to argue that the Fourth Circuit en banc panel's decision in the Snope case, which deals with the Maryland ban on so-called assault weapons, also supports a California magazine ban. In that letter, California argued that the Fourth Circuit considered a Second Amendment challenge to a Maryland law banning assault weapons, after rejecting plaintiffs' facial challenge because plaintiffs failed to show that each firearm regulated by Maryland statute is within the ambit of the Second Amendment. The court considered the constitutionality of Maryland's restrictions on AR-15s. The court applied Bruen's two-step methodology and concluded at the first step that the covered firearms are not within the scope of the constitutional right to keep and bear arms for self-defense. So California argues that the Snope case, which was prior Bianchi, and the whole use of the military use analysis actually supports the California ban here as well. And in some ways, they're arguing that these magazines are maybe useful military service and therefore could also be restricted, and that these magazines are not arms and therefore they're not protected by the text of the Second Amendment. And now California has also submitted a decision out of the DC Court of Appeals, which upheld a similar magazine ban out of DC. The recent supplemental letter of the state of California states that appellant's right to notify the court of the decision in Hansen versus DC. The DC Circuit held that plaintiffs were likely to succeed on the merits of their Second Amendment challenge to a restriction on so-called large capacity magazines that is nearly identical to the California law at issue in Duncan. At Bruen's threshold inquiry, the court held that the magazines likely qualify as arms, and it presumed for the present purposes that they are in common use for self-defense today and therefore presumptively protected. But it rejected the argument that the number of a certain weapon in private hands by itself can establish that the weapon is in common use for self-defense. It also rejected the argument that to find an arm is in common use renders any restriction of that arm unconstitutional. Turning to Bruen's historical inquiry, the court held that the district here has met its burden to show its magazine cap is consistent with the nation's historical tradition of firearms regulation. Although the court did not accept certain analogs advanced by the district, it reasoned that the historical restrictions on particularly dangerous weapons and on the related category of weapons particularly capable of unprecedented lethality were relevantly similar to the challenge restrictions. The court also reasoned that a more nuanced approach to the historical analysis was required because large capacity magazines have given rise to an unprecedented societal concern, including shootings, and because they are a relatively modern invention, different in form and kind from arms in common use during the founding and Reconstruction era. So here what the state of California is saying is that the DC Court of Appeals looked at a similar magazine ban, found that these magazines are potentially arms, but potentially just because they're owned by millions of people and they're in the hands of millions of people for purposes like self-defense does not mean they're in common use at the sheer numbers, does not mean that they're in common use. And also they're arguing for the more nuanced approach, which is also mentioned in the Supreme Court's decision in Rahimi. So they want more wiggle room of an analysis when it comes to looking at the California magazine ban. Now, in reality, I don't suspect that the Ninth Circuit en banc panel will change their decision drastically based on the Rahimi case, Bianchi, or this DC Court of Appeals decision. I think that the Ninth Circuit en banc panel has made up their mind a long time ago when it comes to the Duncan case and when it comes to upholding magazine bans. I think they took this as a comeback case for a very specific purpose, which is to once again uphold these magazine bans. But no doubt this case will eventually make its way back to the Supreme Court. So that's where the California magazine ban currently stands. If anything else changes, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.